Hi there, Doc from Barcast Audio here, today to talk with you today about hearsay exclusions versus hearsay exceptions and what the difference between the two is as tested in law school and on the bar exam. Before we get started, be sure to check us out at barcastaudio.com for audio outlines, essay attack sheets, whatever you may need for the bar exam. Also be sure to subscribe to this channel for more of these videos. So I've done a couple other videos on evidence on the rules of hearsay, but let's talk in this video specifically about the differences between hearsay exclusions and hearsay exceptions. To begin, hearsay exclusions are non-hearsay statements which have categorically been provided for by the federal rules of evidence. There are four important ones to remember. First off, prior statements of identification. Second off, prior inconsistent statements. And third, prior consistent statements. And fourth, party opponent admissions. Let's talk about each of these in a little greater detail. First off, prior statements of identification are admissible hearsay exclusions for substantive purposes. So an example here would be that Jake's out-of-court statement that the bicycle that struck him was orange would be admissible as a prior statement of identification. It would be a non-hearsay exclusion because it was technically an out-of-court statement, but it would be used to prove the identification of the vehicle that struck him. Next up, prior inconsistent statements may also be admissible for substantive purposes, where one, the statements were made under oath, second, the declarant was subject to cross-examination at trial, and third, prior statements were inconsistent with trial testimony. Keep in mind that prior inconsistent statements, which were not made under oath or under threat of perjury, are not admissible for substantive purposes, but may be admissible for impeachment purposes. Okay, that brings us to prior consistent statements. Prior consistent statements are admissible to rebut an allegation that the declarant was lying or had reason to lie at trial, where one, the declarant testifies at trial, and two, is subject to cross-examination, and three, the prior statement was made prior to the declarant having any motive to lie. That brings us to party opponent statements. A party opponent statement is any statement offered against an opposing party that either one, was made by a party or an individual acting in a representative capacity of that party, two, is adopted by a party, including by way of silence, if a reasonable person would have denied a statement after hearing it. Three, was made by a party's agent or an employee within the scope of their relationship. Four, was made by a co-conspirator during or in furtherance of a conspiracy. Or five, vicarious admissions made by a person authorized to make a statement on a party's behalf. Let's talk some examples here. Todd sues a grocery store after he's injured after sliding on the floor of a grocery store. After falling, Todd was confronted by the store's manager, Carolyn, who admitted that she should have had an employee wipe up the wet spot on which Todd slipped. Is Carolyn's statement inadmissible as hearsay? Answer. Carolyn's statement would be admissible as a non-hearsay exclusion because it is a party opponent statement. Carolyn is a manager and thus an agent of the grocery store, and therefore Carolyn's statement would be an admissible non-hearsay statement. This concludes our discussion of the hearsay exclusions. Be sure to check us out at barcastaudio.com. Be sure to subscribe to this channel for more of these videos. Until later, I will talk to you guys soon. Bye now.